Got it. Good morning, everybody. If we haven't already met, I'm Richard Kistner. I've worked quite a bit with Lucky and Jazz the last couple of years. I've also worked with many of you, although I don't think all of you just yet. My office is just down the block on 12822 Rockaway. So I help out LJ with a number of their contracts, just to expedite things. And so I think today this session is about reviewing the contract. And I think so. Just know that. Let me preface this by saying that the contract, generally speaking, is actually pretty straightforward between and amongst most attorneys. There's generally going to be two parts to it. There's the form contract, and then there's a rider. So we'll explore some of those things. And so the contract itself isn't terribly complicated. If you're using most attorneys that use the form, it's language that every attorney is familiar with, so we can get through quite kind of quickly. The real meat of it, of any contract, is probably going to be in the rider. That being said, the most important part, or I think everyone wants the contract to be reviewed and signed as quickly as possible, right? Myself included. No one wants to delay a deal at all. You want in and out. And so that's why I've shared this before, and I'll share it again. I'll share it tomorrow. I'll share it the next week and the week after that. The most important part of it is having a deal sheet that is all inclusive and encompasses every single detail. So as you know, take a look at this form. This is the contract that I use. Anytime if you represent the seller, for instance, one of y'all, and you say, "Hey, Rich, we need to send out a contract," this is what I'm going to be using as a form. And you'll see as we go, just kind of glide through it, a lot of the stuff is very simple. What the details are about the real meat of a transaction that usually ends up either breaking a transaction is where those details that I'm talking about. So before we start going in a little more in depth in the contract, any questions or comments right now?
No, nothing right now.
Take it as no. All right, let's go. So you'll see right off page one, very simple. It's in just Lucky. I want to confirm that this is easy to see.
Yeah, easy to see. Anyone
Okay, cool.
having any trouble? I just want to.
All right, so very simple. First page is you're gonna have the date of the contract up here, and this is actually where when the seller signs, that's the date of the contract, not when the purchaser signs. Very basic information. You want to have the seller name and purchaser name. Just a note, sometimes on the deal sheet, I'll receive deal sheets with like just a last name. That means I have to add a step and then go to Acris, go to public records to find out who's on title, right? If somebody is dead, it adds a layer. And I think that for everyone, if speed is what you're after, you want to have as much detail about who the seller's correct names, the purchaser's correct names in the contract. So if there's going to be multiple people on the mortgage, for instance, for purchasers, you want all those purchasers on the contract. If not, what's going to have to happen is that later on, there's going to have to circulate an amendment, and amendments to go from lawyer to lawyer, then to the buyer, then to the seller, all adds time. So it really helps. Sometimes you can't help it, right? If in the mortgage process, it turns out that a buyer needs additional people on it, then fine. But if in the beginning there are going to be 3 buyers, you want all 3 buyers properly on the contract. So just know that in the deal sheet from now on, when you're prepping it, just do an extra check. Do I have all the sellers? Do I have all the buyers? Down here is the property address, block and lot. Pull up. Here's where often overlooked, but any kind of property that's going to be left on the property or taken out. Generally speaking, with a house, everything that the buyer sees at the date of contract is presumed to be included unless it's excluded. So if there are going to be things that a seller is taking out, or let's say there's personal property that the buyer wants in, that has to be addressed here or somewhere in the contract. So if there are, I always call it special conditions, right? If there's something that the parties in terms of property are negotiating over either removing or leaving on the property, you want to make sure that that's somewhere on a deal sheet. Buyer's going to leave. I had a deal recently where there were no agents involved. So it was just buyer selling to a neighbor. and then all of a sudden when we closed, the sellers took out the washer and dryer. Like, well, the buyers thought that that was staying, right? It was something overlooked because there weren't any agents, but that's where you come in, and you can offer that value. Make sure that everyone understands, buyer and seller, what's on property, what's staying, and what's going. Here's going to be just purchase price. Down payment on contract goes here. Down payment on contract different from maybe the total down payment that a buyer has. This doesn't matter too much. Just know in the seller's market, sometimes people are asking for more than 10,000, 20,000 down. They want to see more on contract. The trick or the challenge for buyers, that the more you put down on the contract, if something goes wrong later on, then it could be a problem to get that money back. So as a buyer, you always want to reduce the amount you put down. As a seller, you always want to increase the amount that the buyer puts down on contract. Any questions with any of that stuff right now? Very basic stuff, but I think all of that should be, again, if the goal is getting a contract out and signed as quickly as possible, all those pieces of information ought to be on a single deal sheet. Not it's in MLS, not it's in here, not between three different forms. It should be in one precise form. So I know that LJ uses a pretty in-depth form. If there are things that you think are missing on there or ways to capture that data, put that on there for yourself. Like, have your own, add to it, or make it a little more usable so that all those pieces of information are on there. If those things are there, it just makes life a lot easier, and the process to get the contract in and out for me or any lawyer a lot easier. So next is going to be, I think, the thing that is really pressing, and sometimes this gets overlooked as well. And this is one of these things where it's like, well, look at the pre-approval, the mortgage contingency, right? If the buyer, whatever the buyer's putting down, if it's FHA, if it's conventional, just make it as clear as possible, because it doesn't take a lot of space just to put on a deal sheet that buyer's putting down. If you want to do a percentage is easy, or the total amount down and the type of loan. It's just every time that we have to go through documents and then check out, refer to another source, it just adds friction. Sometimes, like in Teams, for instance, I was talking to Jazz about this the other day. Like some of the documents aren't named clearly, and then so we have to like go back and see. Well, go through 5 documents to find one document. Again, it maybe adds a couple of minutes, but a couple of minutes times multiple contracts, and that's where you start seeing a delay. So on a deal sheet, just if the buyer's putting down 20%, cool, 20%, and the type of loan, conventional or FHA, just so everybody's very clear about that. Next, if violations, I mean, probably not too common, but if you do have a buyer that's taking with violations that exist, you just want to make sure that that's clear on the deal sheet as well, because deals fall pretty quickly once you start saying, oh, violations going back and forth. So you want to make sure that any issues with any open, I try to do when I represent a seller and a buyer, look for just real quick. Actually, let me take a step back. For those of you who aren't aware, you can look up a property, and this is maybe another value add when you're working with a buyer and working with a seller. Just Google NYC BIS. That's the Department of Finance Building Information System. And when you punch in any address in the 5 boroughs, it'll show you pretty quickly if there are any open violations, DOB violations, ECB violations, certain permits, certificate of occupancy. If you can incorporate that, one, again, it probably sets you above and beyond what the kind of work that a lot of other agents are doing, and it just makes it a lot clearer for the attorney. I mean, I'm looking at it anyways, but just between you and your client, just so you're very well aware of what kind of property you're dealing with. If there's anything that you want to get ahead of, especially with a seller, if a property has violations, you want to get ahead of it and make sure that your seller is aware of that before like sending out contract, and then later on finding out that, oh my gosh, there's this huge problem. So that's I think a good value add that you may want to incorporate. Condition of property, again, just anything in the physical condition of the property. Are they taking it subject to any kind of any damage that people are aware of and whatnot? Generally, the contract is that and when it's as is, at the time of contract, is the same thing that the buyer's getting at closing. So if there's a broken window, it's a broken window that's going to be there closing, right? So you just want to be sure, especially for representing a buyer, that they're aware of what exactly they're getting at closing. Nothing more, nothing less than what it is at the time they sign the contract. Let's keep going through here. Closing, the closing date is, it's not a firm date. Like if this doesn't close on or this date, buyer or seller are in breach. The closing date is more of a guideline. Even further down inside the form contract, a seller, for instance, if there are things that show up on a title report, they have up to 60 days to cure those items without being in breach of the contract. And that's just a form contract. Customarily, if something appears on, let's say, a title report that no one had a way to figure out, that's where that comes in. So just keep in mind that the closing date in the contract, and speak to this with your buyers, especially right now as rates are very volatile, the closing date in the contract is just a guideline. It's not a firm, it must close by this date, otherwise the seller is in breach or the buyer is in breach. What else? Any questions thus far? I know we're kind of streaming through this, but
No, I think I have a few questions, but I think after we go through it, we can ask everybody.
All right, fair
I
enough.
think keep going. It's really good. Yeah.
Yeah, 17, transfer taxes. Just know in New York City, particularly, transfer taxes, right? So especially if you're representing a seller, they're probably going to ask you, what am I walking away with here? For residential properties, right? 1 and 2 family houses that you're selling, the tax is as follows. New York, it's 1% up until $500,000, and then 1.425% above $500,000 and above. And then the state, there's a transfer tax of 0.4%. So really, when you just do the math, it's under $500,000, it's 1.425%, and then 1.4%. Sorry, and then above $500,000 and above, 1.825%. So if you're doing quick math and so it's like, what am I going to walk away with? Well, purchase price minus commissions minus transfer tax. Forget about adjustments because that's like a couple $100 here or there, and last minute. The transfer tax is a big thing. Seller pays the transfer taxes, New York State and city. If it's a purchase price above $1 million, $1 million and above rather, it's the purchaser pays the tax on that. And the other thing in terms of transfer tax too, concessions. If you end up having a deal where the seller is giving a concession, just know the buyer is responsible for the transfer tax on that concession. It's a couple $100, but they should be made aware of it as well. What else? I think the end of this contract is not that important at this point. I guess for brokers, you want to make sure that you're in the contract. Otherwise, the seller doesn't have to pay you. So just make sure that the contract includes your brokerage. That's that. So that's the form contract. Again, every deal sheet, the points we kind of touched on in here, the names, the purchase price, down payment, the type of loan, the amount of the mortgage contingency, any special considerations, conditions, or property, all of that stuff ought to be on every single deal sheet. It doesn't take a lot of space. All of that can fit in like half a page. So just as you're moving forward with whatever your next deal, just check yourself, right? Do I have these elements? Because that'll help make the deal and the contract come in and come out a lot more quickly. So now the rider, every attorney has their own right. This is the rider that I use. The form contract kind of is the template just to make it seamless between attorneys. The rider is where any special changes would exist, right? So if you're, I don't know exactly how if there's any, I guess, out of the ordinary things, that's going to be added as something here, right? So if you're talking about taking violations, you might probably add it inside of the rider. If there's waiver of appraisal, if there's taking with tenants, all of that comes into a rider. So if the deal sheet doesn't have any special things, let's talk about a tenancy, right? If, excuse me, a deal sheet doesn't include if a property is coming with tenants, the rent, the down, any security deposit. It's not a lot of work, but again, buyer attorney has to contact the seller attorney, get that information. There's delay there, and all those little delays cause like bottlenecks. And so to the extent that it's possible, if the goal is getting contracts in and out as fast as possible, all of that should be on a single page of a deal sheet or whatever, 2-page deal sheet. So anything that would be, I can't run through, I don't think I can identify every circumstance, but you want to have as much detail, especially particulars, tenants, repairs, violations, post-possession is a big one right now. You want to have all of that on a deal sheet so that when the contract is being drafted, contract goes from seller attorney over to buyer attorney, both to avoid having back and forth. It might be a quick phone call, it might be a quick email, but 5 of those emails back and forth end up delaying the contract getting signed. That's what we're trying to avoid here. So you want to have all of that on the deal sheet. What else is here that matters right now? Let's talk about, I think I want to touch on the big one, which is post-possession. It seems to be a big one right now because of a lot of sellers selling to buy, and then that's causing some delay on the buyers. Just know that right in a seller's market anyways, the seller has just a little more leverage, right? And if they're getting into contract, kind of like I said before, the closing date in the contract isn't a must-have, it's just a guideline. And you know, a lot of sellers are now saying that the contract could be like this, like paragraph 20 you see here, post possession will be delivered vacant, room clean. But then if the buyer is trying to protect the rate lock, right, and schedule closing so that they avoid buying down points or whatnot, buying down the rate or something like that, and they get to closing, this doesn't control, right? Because now you have to negotiate with the seller side. Hey, we as a courtesy, we'd like if we can close before the buyer's rate expires. Would you be agreeable to post possession? And then you got to negotiate back and with the seller side, how much time would they need, right? So as more and more contracts are like this right now, or not the contract, the experience is like this, where a buyer is getting into contract, seller is waiting to close or do something else, just know that that's going to come up. So if it seems like initially we can get ahead of it, and we know that a seller, for instance, is going to stay on the property, maybe we include a post-possession in the contract, so there's no ifs, ands, or buts. But if not, and it's something that has to be negotiated downstream, this is something that you can coach your even buyers right now from the beginning. Let them know that, hey, this is a very volatile market. You have a lot of sellers that are selling to buy, so it might be it's very common. It might be the case that the seller is going to have to stay on the property after closing, just so there's no, in addition to like getting the contracts in and out, you want to have like the experience be better for buyers and sellers. So if you can get ahead of them and say, these are experiences that are common right now, it just makes life a lot easier. But that's it. Again, it's not complicated. A lot of the language in here is pretty familiar for all the attorneys in the neighborhood in New York City. The form contract plus most of the riders are pretty similar. It's just two things. The more information that we have in the deal sheet makes life a lot easier for everybody. And then just getting ahead of certain circumstances, I think, really elevates the experience for buyer and seller.
So thank you for that. Thank you for that, Richard. For post possession, right, amount in escrow, what percentages do you recommend that if we're as realtors, we're telling our, we're the listing agent, or the buyer's agent, what amount should be, that you see in post possession amount held in escrow
There's no
until the deed?
baseline, right? It really depends on the length of time. I think at a minimum, I would ask for, even if it's like 5 days, I would ask for probably 5,000. I think realistically, most attorneys would agree if it's something that's that short, probably like 3,000 is what they would agree to. But I'd ask for at least 5,000. And anything above that, it gets very dicey. Why? You got to make sure that there's enough money to protect against damages. That's the biggest thing. If there's a fire, if there's a flood, if there's a pipe burst, if there's something that breaks, once closing occurs, it's the buyer's house, right? And even though the seller may say, yeah, we'll take care of it, if something happens, let's take for instance, I don't know, there's a pipe burst, right? I don't know. That might not be the best example because there's insurance coverage, but let's say something with a hot water tank. And just because everyone wants to close, let's agree to keep $1,000 in escrow. To replace some hot water tank or something, it might be, let's say, $3,000 or $4,000. Seller's gonna say, you know what? No, take the $1,000, right? So you just got to be, especially if you're on the buyer side, you always got to get ahead of it and say, how much would it be okay to protect my client? So I think at a minimum 5,000. when you're asking for some of these post possessions like 30 days and whatnot, or if there's like tenancy issues, you're approaching $30,000, $50,000, because
Yeah.
the longer it goes, just the bigger risk exists, and you want to mitigate that.
Yeah. Yeah. I think, yeah, the larger the amount that, the faster they will probably want to leave and get that money back.
Yeah.
Yeah. So yeah, good stuff. I have a few more questions, but anyone else has questions for Richard?
I have a question about the closing we were supposed to do today. Janine's closing
Yeah.
for 29th Street.
Sure.
Yeah, so I have a question for Richard. I remember you saying that we should be good for the closing, but the buyer called me today and said that it's not possible, and she was so hopeless. She said we might not be able to close this deal because the sellers could not provide the documents we need, and she's concerned about her interest rate going up. So can Richard explain like what's going on?
So I just want to make sure you want me to talk about an individual deal on this call. I don't know if it's being recorded, if this is going to be used for
Yeah, yeah, yeah,
edification.
yeah. Let's not do that. No, no, no. Let's not do that. Rupinder, after this call, you can
Okay.
call and yeah, yeah. But just in case, like if you have a schedule, we can be vague about it, right? If it was just a scheduled, a closing schedule for today, and the seller did not provide any document, it has to be rescheduled. I'm pretty sure, right, Richard? In a situation like this.
Yeah, I mean, there are responsibilities on buyer and seller to get to a closing, and it was, it seemed like based on what occurred, and again, I don't want to dive in because this might be used for
Yeah.
other things. Um, there, it seemed like I was represented to that everything was available and lined up for closing. Unfortunately, there were things that were missed on the seller side that we can't close.
Hmm. Yeah.
So
Mhm.
okay, I'll contact Richard afterwards.
Sure. Yeah, we can talk in details. Anyone else regarding the contract? Just a general question. I think everyone should ask or be concerned the escrow amount when he said, or the down payment that we're putting down, right? The earnest deposit. Let's just say we're putting down $10,000, 20,000, 50,000. How secure is that? If you're representing the buyer.
So generally speaking, the way every time I meet with a buyer, I share the following: you have a responsibility as a buyer to, in good faith, get your mortgage, and as long as you do that, your down payment should be secure. It's intended to prevent people from like putting down a deposit here, a deposit there, and then holding three deals up and then trying to finagle something. As long as the buyer does their job and goes after, oh, I mean, in due diligence, provides the documents to the loan officer. If it's denied, the lender denies it, you get your down payment back. If the appraisal comes in short, provided you didn't waive the appraisal, you get your down payment back. But this also turns back to the kind of mortgage, right? When it's not clear, you can't just, something that I've experienced a couple times, you can't assume that a seller will be okay with an FHA loan, right? So if, and this is why the contract needs to be very clear from the beginning. If in theory it's going to be a conventional, or you're not sure, you just want to be sure about it, because later on, if you send an FHA amendment to say that the purchase price or the appraised value has to match the purchase price, a seller may say no, that wasn't the term of the deal. So I think that's, as long as you act in good faith as a buyer, your down payment is safe. And then after that, I don't know what other circumstance there is. It's just, you just never know what happens on the back end of the deal. Um, so if a buyer's reluctant to give up a large chunk, that's something to consider too. I wouldn't just say, hey, they're going to do the right thing and put down $100,000 down payment on something, right?
Yep.
On a $500,000 house. So I think most people are. I don't think I've gotten a contract that's been so unreasonable. It's even on the high end, it's probably like 10% just because it was a really hot property or something like that. But otherwise, at most, there's no dollar value, but let's say 50,000 or something like that, 80,000. It really depends on the circumstance of what somebody is, I think a buyer is saying.
Hmm.
Um, Yeah, I don't know if that was a ramble. I don't know if I answered the question.
Yeah, that's fine. And just going back to the post possession, and if the person has a FHA loan, and FHA loan that the buyer must live there, and now we're saying that they're not gonna live there for 30 days. You think the loan officer, maybe Josh can answer that, or you can answer that? Will the loan have the bank will have any issues with that with post possession?
I'm not aware of any issues at closing because the loan is based on you being for primary residence, and you
Hmm.
intend to use it as your primary residence. Just because it doesn't occur on the very day of closing doesn't change, transform, or transmute the kind of loan or the purpose of the loan. But I don't know if Jazz has anything else on that.
No, they don't have no issue.
Okay. So as long as they close and they intend to live there, there's no issues. Okay. Sounds good. All right. Any other questions, concerns, guys, for Richard? I have a few more
Yeah,
questions.
I had to add a question regarding credit. If seller agreed to give a buyer credit and buyer I guess accept the credit but want to go back because what he thought the amount would remedy the issue couldn't remedy the issue for the amount, can he go back and ask the seller for more?
The short answer is probably not. Let me take a step back. You could always negotiate, right? In between the time you sign contract or before contract and closing, you could always negotiate and say, listen, you want to do this or not, right? So let's say, presumably here, you have a contract where, I don't know, there's something that needs a roof, right? And so the seller agrees to give, hey, I'll give you a $5,000 credit for roof. And then before, let's say before you get to closing, the buyer finds out, no, it's going to be a $15,000 job, right? Is that what I understand the circumstance to be, or like the example?
Yes,
Yeah.
perfect example.
So after closing, they're dead in the water. They have nothing they can go back to the seller for. Absolutely not. So up until before closing, sure, you can go back to the seller and say, hey, we miscalculated. Right? I doubt a seller, especially in this market, would have any sympathy for that. And that's why anytime you have an inspection report, one, you always encourage, I always encourage a buyer, even though it might add a delay to get contract, get an inspection report, because you can't, it's not enough to say, I wasn't aware. You're supposed to do your due diligence as a buyer before you sign the contract. So if there are issues that come up, I'm not a contractor to even to negotiate that, right? So if there's something that appears on an inspection report that a buyer wants to negotiate, they need to get it might take some cost, it might take some extra work, but they need to figure out what number makes sense for them, because it's going to be very rare that you'll have a seller after the fact say, yeah, I'll increase a credit. The reason is you got to think about like what leverage you have. If you say as a buyer in that circumstance, you know what, I'm not closing. All right, then you lose your down payment. You're in breach. What leverage do you have as a buyer in that example? If it's a buyer's market, then maybe it's a different story, right? And I don't know what that would look like. But right now, for instance, if you're in contract and you tell a seller, "Oh no, I was short $10,000. Can you increase that credit by 10,000? Otherwise, I'm going to walk away." Go ahead. You lose your down payment, and I have a buyer lined up by tomorrow. So I think anytime you have something like that, a repair or credit that's being negotiated, you want to be as thorough and, I guess, ahead of it as possible. So if it is going to be, you think it, don't. I think it's better to think conservatively than optimistically, right? So if it's like something that repairs, ask for. If someone tells you 3,000, ask for $5,000, right? And then negotiate your way down, I guess. But if you're on the other side of it, where you negotiated $5,000 and it turns out it's a $15,000 job, more likely than not, that buyer's out of luck.
All right, great.
Thank you.
All right. Anyone else with any questions or concerns for Richard? All right, guys. So the whole point of this meeting was to educate you, right, for the contract, so you guys know. If you want your contract to be signed quicker, as Richard mentioned, you want to make sure your deal sheet is thorough, right? That's what my takeaway is. And the names that he mentioned, right, we use geodata right? Everyone has access to that. So it will show you who's on the deed, right off the bat. So that if it's two people on that, both of their names should be on the deal sheet, right?
Can I ask one more question
Yeah, yeah,
before
sure,
you continue? Look, it just came to mind.
sure, go ahead.
It's been a situation where a seller would sign their name differently in different documents, and that would slow down closing. So is that what we were mentioning before? I don't know if I missed it or not when you said that you would do an amendment to get different signatures for that seller, or I mean for that buyer. Excuse me.
So there are a number of reasons. Like it. Let me try to cut this different ways. So on a buyer side, right? Sometimes they'll have like they'll say their name is like me, Richard Kistman, and then during the loan application, let's say they have a middle name, right? And
Right.
they normally don't use it, and then the bank says, oh no, we need an amendment to include the middle initial. Okay, you can't help that, right? It's fine, it's not a big deal. What I'm saying is that sometimes you have like on the deal sheet, um, one seller, a last name or something like that, right? And you
Hmm.
have just one name of a buyer. So you send out a contract, and then later on you find out you have like two other sellers or two other buyers. The reason why you want to do that as early as possible is because, especially on, well, not as just the buyer side, but both buyer and seller, when you get the title report, the searches are against the bank wants to be sure that there's no lawsuits, liens, anything impeding or impacting title against buyer or seller. So every time if you add someone late, you have to get new searches, and that adds time, that pushes closing back. That's why it's for me it's the better we can be clear about the correct names and who should be on the contract, it makes things easier later on, because if you have to then order additional searches, again, it might be a day or two, but it's still a day or two that you're pushing closing off.
Yeah. And he's definitely when Richard is checking the public records, we're doing it through geodata, especially when we're the listing agent. So just type in the address. If you show two names, clarify that, those are the people going to be on the deed. So just to save you guys some time. And another note was your renaming the files, right? That's just not for, Richard, for our teams, but that should be in general. Any file that you have, if it's a pre-approval, write the word, rename that file to pre-approval. If it's a commitment letter, you write the word commitment on it. So it makes everyone's life easier. Even when you're sending a document to the listing agent, to any party, it will make you, look professional. Um, Also on the writer, I think, again, um, once your offer is accepted, you want to schedule the home inspection right away. So this way, if there's like, 10 things on the inspection report, right, that needs to be fixed, and both party agree on fixing two of them, those two items should be notified on our deal sheet. We have four blank lines there. You can say, hey, they're willing to fix these two things. And the attorneys, Richard, will add it to as a writer. So again, we want to be professional. We don't want to go back and forth until the contract is fully signed. All these steps we can avoid and make things go much more smoother, right? Any, I think that's it from my end. Richard, you want to add anything, guys? You want to have any questions, concerns?
But Richard, if somebody don't want to do a home inspection,
You mean the buyer or the seller?
the buyer, sometimes seller too, they don't want to wait the contract. They want to sign the contract soon as possible, and they said they don't want to let them to do any home inspection.
Yeah. Well, a seller's well within the right to say that they don't want a home inspection, right? And as a buyer, you got to make a decision. Do I want to spend or get into contract with a house that I don't know the condition? I'd always be wary about that. There's plenty of stories on your news feed that you see homeowners who bought houses in the last 2 years that have waived inspections, and all of a sudden they have a headache on their hands that they can't afford. So I would always tell a buyer, listen, if you're going to buy a $500,000 house, spend the $500 on inspection. And if a seller doesn't want to do that, I mean, I don't know, is that particular house that important
Yeah.
to you? I understand it's a tough market, but is that important? On the
Even
seller
if they don't want to
side,
fix it, right? Even if
yeah,
they don't
even if
want to
they, yeah,
fix it, they don't want to fix it as a buyer, they should still get it done.
to know what
Yeah.
exactly, hey, is it, yeah. On the buy, so buyers, if they're gonna waive it, that's on them, and then sellers don't have to do it. I So
Hmm.
I don't know how it is. It's just
The seller doesn't care. He wants to sell it as is. He doesn't. If
right.
there's no inspection, he said, "I'll take that offer because it has no inspection contingency compared to the other ones." But at the same time, for the buyer side, I think just like how we mentioned for survey, they're not required, but they should be done. You're purchasing a property for X amount of money. You should spend a little bit just to know, hey, this is my this is where my land is. Same thing for the inspection. You should know what the problems are. It's not necessarily that the seller will fix it or agree to fix it, but this way you know what you're getting into.
And another thing about Richard about the survey. Some customer want the borrower want to survey, some don't want. So what we should do?
So again, just real briefly, a survey is a map, an actual map of the property that shows the boundaries, right? And then anything that may encroach. Again, some banks don't require it. It's a matter of title insurance, and some banks do require it. If it's a bank that does require it, just know that the buyer has to do it. Again, it's another thing just along the lines of a home inspection, right? It's, let's say, $700, but to know the there's a look in Queens, right behind us on Rockaway Boulevard, right there are plenty of how people have come to me just behind the block where it was like, hey, my fence is here. It turns out that the property line is like 10 feet after that, but what can I do about it? I'm like, okay, go spend $50,000 in Supreme Court to go fight that case that someone is encroaching on your land. Once you close, it's the buyer's property, and when it's the buyer's property, it becomes their problem. So to the if it's $700 to find out, hey, there's a fence that's 3 feet in, or there's this or that, I can only, as a lawyer, I got to say, listen, you should spend the money to know what that is. Otherwise, just know at the end of it, right? Don't call me 2 years and say, hey, we closed, I didn't get a survey, but now it turns out that there's a fence that's 3 feet in on my property. That's what you want to be aware of. So if a buyer doesn't want to do it, you can't force somebody to spend the money. But I would always implore them, listen, as an attorney, and I think also as an agent, you just want to um, give the representation to your client. I think this is a good idea, and if
Yeah.
they turn it down, they turn it down.
Yeah, just giving them knowledge. So this way, that what makes you guys stick out. Providing knowledge. If they tell you what is a survey, how much it costs, why do I need it? If you just like how Richard just mentioned, if you just explain it in that form, trust me, you will stick out, and they'll remember. And if things go south, they will, years down the line, they will say, "Hey, my realtor never told me this," or my. So I think you should just always educate them and let them decide if they want to do it or not. Right? Any other questions, concerns, guys? This is much longer than what we, wanted to go, but I guess it's helpful. But yeah, any questions, concerns?
Yeah, yep. Hi, good morning, guys.
Yep.
So, I have a question. I have one deal ongoing. I mean, the offer is almost accepted, but when I saw the geo data, there is list pendants on the property. So, can you guys advise me? I have to go ahead for that, or this is, I mean, the deal is good, or this can be risky for the buyer?
I will say this much: it's very risky for the buyer. A list pendants represents that there's some kind of lawsuit or litigation that's pending between two parties involving that land. Sometimes it could be fraudulent, right? So you don't know unless you have more information. But generally speaking, if you have a list pendants, the look, it could be something small, right, where maybe somebody owes somebody else a couple $1,000, or it could be something huge where there's a dispute over ownership of the land or whatnot. I received a deal. It was a friend of mine, and he was trying to purchase a commercial space on Queens Boulevard, and that oh, as soon as I got the deal, I looked it up. I'm like, wait, something's not right here. It's found a list pendants, and the owners that developed that unit were fighting over ownership. There was like transfer of corporation, blah blah blah. And so I told him straight up, no one's going to give title insurance on that. So the short of it is, when you see something like that, you want to just be straight up and ask the seller, what's this about? It appears here. Let them give you more information. If they can tell you, right? If it's a foreclosure, for instance, a foreclosure requires the bank is going to file a list pendants. If it's a foreclosure, then maybe not a big deal, because if they're selling the property and then they're just going to pay off the mortgage at closing, who cares? But if it's something a little more a little more intense, fights between prior owners that or family members that are arguing over the property, then you want to be careful. And the reason why the buyer's at risk is, think about it, they're going to get into the contract, their rates are volatile, so maybe they want to close within 45 days to protect the rate. That lis pendens, if it's something more challenging, that probably won't be resolved. So then all of a sudden the buyer wasted that 45 days in contract. They're going to spend money on whatever, appraisal, blah, 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 with the loan. They come out of pocket, and then at the end of the day, they're not going to be able to close anyways. So I think you just, if you see the lis pendens, that's a good thing. Just ask the seller outright, what's this about?
All right, sir. Thank you very much for the information, sir.
Yep. All right, guys. Anyone else? All right, Richard. I think thank you so much for your time. I think everyone should be good, right? I'll just give it a minute. No questions here. All right, guys. I think that will do it. You guys can get going one by one. I hope you guys did learn something from this. It is being recorded, so I'll post that for people that couldn't make it. But you guys know how to reach Richard and teams. As soon as you're about to go under contract, we created um, a channel in Teams with you guys, right? So just to keep your the whole transaction go smoother, because it typically takes about 2 months to close a deal. So you want to close it as smoothly as possible, right? So we can get referrals and stick out from the rest of the agents and be professional. All right. If there's no any other questions, you guys can really get going one by one. All right. Thank you, Richard, one more time.
Take care, y'all. Have a good day.
All right. Take care.
Thank you, guys. Have a
You're
good day.
welcome. Right. Yep. Have a good day, guys.
Thank you.
You're welcome.